Hi everyone, my name's Daniel Kriegers. I'm an employment lawyer at Chadwick Lawrence Solicitors. This video update focuses on the legal obligations placed on employers in relation to discrimination and harassment in the workplace, particularly in light of a recent case which was critical of an employer's defence. Now, as you'll no doubt be aware, it's unlawful for employers to discriminate against employees based on 9 protected characteristics as defined in the Equality Act 2010. There are a number of different types of discrimination that the Act affords protection from. And of relevance in this video are direct discrimination, that is treating someone less favourably than they would treat others because of a protected characteristic. And of particular relevance here, harassment, which occurs where the employee engages in unwanted conduct related to a relevant protected characteristic, which has the purpose or effect of either violating their colleague's dignity or creating an intimidating, hostile, degrading or offensive environment for the other. Now, importantly, it's quite possible for employers to be deemed vicariously liable for acts of discrimination and harassment carried out by employees in the course of their employment, and regardless of whether or not such acts were done with the prior approval or knowledge of the business. Now, typically when an employee brings a claim of this nature under the Equality Act, they will pursue the employer because they have means, they have the financial ability to pay, but employees may also be listed personally as respondents to any tribunal claims. Now, this notion of vicarious liability might appear to be an unfair obligation on employers. They may say, well, we had no control over the way in which the employee acted. We shouldn't be held responsible for the actions of others. Now, the Equality Act does afford a defence in this situation. And essentially, if an employer can show that they took all reasonable steps to prevent the employee from carrying out the act of discrimination or harassment, they would not be found liable. The risk to employers, should they fail to demonstrate they've taken these reasonable steps, was highlighted in a very recent case before the Employment Appeals Tribunal, and that was Allay, UK and Gehlen. So the Appeals Tribunal upheld a finding that the employer failed to take all reasonable steps to avoid an employee or prevent an employee from being racially harassed by another employee, and in the circumstances could not rely on the reasonable steps defence under Section 109 of the Equality Act. So the defence raised by the employer centred around equality and diversity training, which was delivered to its staff. Many businesses do provide this training either as a one-off, regularly, as part of an induction. The tribunal in this case found that the training which had been delivered had become stale. The content of the training was insubstantial, and it took place 20 months before the incident, the alleged act of harassment, took place, and the employees were considered in that case to have forgotten the content of the training. The tribunal found a further reasonable step would have been to offer further refresher training, and as the employer failed to do this, they were found not to have satisfied the reasonable steps defence and were therefore vicariously liable for the acts of harassment perpetrated by the employee. So the case highlights the high threshold that employers will have to meet to prove reasonable steps have been taken to prevent discrimination and harassment. Simply having an equal opportunities policy with one-off or historic training is not going to be a sufficient measure, especially if the content of those materials is not comprehensive. The EAT confirms specifically, and I'm quoting, "brief and superficial training is unlikely to have a substantial effect on preventing harassment, nor will it have long-lasting consequences." So the main takeaway here is that training should be supplied which is substantial in nature, which is regularly delivered, so perhaps an annual refresher session, so that employees do not have the opportunity to argue that they've forgotten the content which has been delivered. So aside from impacting on an employer's defence to a harassment claim, potentially as well, and this applies to any training really, if it does become stale, if it hasn't been repeated for a lengthy amount of time, that could affect the fairness of any dismissal of an employee who could allege that because the training hadn't been delivered for so long, they were no longer fully aware of their obligations or how they were expected to act. So in light of this case in relation to discrimination and harassment, you as the employer should review the current approach that you take to training on equality and diversity. Identify the steps that you currently take to prevent your employees carrying out this type of behaviour, and identify whether there are any other steps that you can take to satisfy this high threshold for a defence to any claim. Now, if you do require some assistance in drafting policies, in delivering training, in helping you to train your employees, or you need advice on any employment topic, please feel free to contact us. Email employmenthub@chadlaw.co.uk or visit the website chadwicklawrence.co.uk for further contact details. Thank you.